Today we're interviewing Judge Eugene MAIER, Senior Judge, Court of Common Pleas in the 1st Judicial District of Pennsylvania. How are you today?
Good.
Good. It's good to have you here. I want to thank you for participating.
Happy to do so.
Okay, that's great. To start out with, Judge, can you tell us a little bit about your background?
Well, background-wise, I've been to the parochial schools, North Catholic, Temple University, Temple Law School. I had a highest grade in constitutional history, wrote an article for the Temple Law Court called the Presidential Franchise, in which we went to Washington to hear the argument on the case, and I was surprised to find out that none of the justices knew that there was no severance clause in the 18-year-old vote case. In fact, none of the lawyers, the Solicitor General, or anyone else, until Professor Wright got up. If you remember, Professor Wright is one who did federal practice from Texas, and told him there was one. Apparently it was him and Tom Leonard, who was with me, and myself, who knew about that.
Yeah.
And the justices knew, the Solicitor General did.
So you're helping them out a little bit. Was the practice of law a lot different when you started as opposed to today?
Well, in the sense that things were, everybody was a lot nicer to everybody.
Judge Shepard mentioned that.
Today it seems that everybody is out to cut everybody else's throat and scream at them and yell at them and things of that nature. I think Justice Flaherty had talked about that for some time, about civility in the practice of law. There really isn't a lot of it now. In fact, I've on a couple of occasions commented to the attorneys how good it was to have them practicing civilly.
Okay.
And it was a much better time then. District attorneys and public defenders seem to get along a little bit better than they do now. And now it's like everybody's screaming, so just like what's happening in Washington. Nobody wants to do anything except get even.
Well, we noticed that just recently, didn't we?
Yeah.
So I guess it's been up to the judge, to yourself, and on some occasions, to control what goes on in the courtroom or how people behave.
Well, I haven't really had any
any
great problem with that, because every so often somebody does something and you have to discipline them. But once you get the reputation, we're not putting up with it. It doesn't happen often. But you can see it in the underlying things, on the discovery and what people say when they're not talking. I mean, there was a time when, I don't mean to sound like it was a million years ago, but 20 years ago, even maybe 30, maybe even less than that, that people at the end of a trial might even shake hands and you could say they could have friends. It just doesn't seem to happen anymore. Occasionally, but not usually.
That surprises me.
Yeah. More so, I think, on the criminal side now than the civil, but...
Well, have there been any cases that you've been involved in that maybe were of a special, or would be of a special interest to the public?
Well, probably to the public, almost everything you get involved in, because it's something something different than you usually do.
It is public service, isn't it?
But quite frankly, I've done pretty much the gamut of everything we have here. There were a couple of cases where I was involved in the case where they were attempting to, the insurance companies, when they went into limited tort and full tort. Case got before me as to whether or not they were required to put the cost for limited tort as opposed to full tort. We had a very, very large hearing, including the secretary or the commissioner of insurance, whatever she was at that time. And we went back and forth, and I think it was pretty clear. It's interesting, in the first part of the bill, the Motor Vehicle Financial Responsibility Law, that it very clearly says they have to, But if you go back to about the last, or the next to last paragraph, it says, they don't really have to. And under statutory construction, that act, which comes later than the first act, controls. I didn't roll that way, and I forget, the Supreme Court did something unusual with that. I forget what it was. They said that I was right, but they didn't change it. I forget, there was something unusual with it, but eventually it got to be that they do.
Yes,
But that was an interesting thing, I think, which affected the public. The rest of them were Primarily cases which were just standard criminal cases or civil cases or things like that nature.
Did you enjoy one more than the other, or?
Well, civil cases, you get, it's a sort of a nicer group of people you're dealing with.
Yeah.
But on the criminal side, you feel like you're doing more. But,
Okay.
You know,
Affecting people's
Yeah.
lives to a
Yeah.
greater degree. Yeah. Would you have any advice to somebody who's just starting out as a judge today?
yeah, but I don't know whether we'd have 4 hours to give them. But
It's important.
there are a couple of things that really, I think one which is absolutely critical, and that is that any person who becomes a judge has to understand that they are in charge of the courtroom, okay? And you can't let the plaintiff or the defendant or the prosecutor or the defense attorney try and take that away from you, as they frequently do.
Okay.
And that's absolutely critical. And if you do it, and it doesn't have to be done in any kind of a nasty way.
Right.
I'll give you a couple of examples. One day I was in family court before I was on the bench, and I was sitting there, and Judge Zaleski had the case prior to me, mine, and he made his ruling, and the lawyer kept talking on and on and on and on.
Yeah.
And finally, after he was done with his paperwork there, Judge Zaleski just looked up and said to the court officer, "Call the next case." The lawyer came in, the guy just moved right out and there's nothing to it. So, now, in that case, that lawyer was trying to affect it, and Judge Zaleski said, "No, very calmly, just
Right.
call the next case."
Okay,
I mean,
yeah.
and I've used that many, many, many times. But that's the most important thing I think a judge has to have is control of the courtroom, okay? And as I say, if there's no, you don't have to be mean, say, get out of here, scream,
Right.
I can say that I don't think in the 30 or so years that I've been on a bench, I don't think there's been maybe once or twice, maybe 3 times, that I've raised my voice to something, and you really don't have to do that.
Yeah.
See, the other thing that I think a judge should understand, that you very quickly develop a reputation among the bar.
Mhm.
And once you get that reputation,
Yeah.
then things go much more easily.
That can help you, yeah.
I mean, as long as I've been on the bench, one of the things that the judges would use sometimes, if they ran late in the day or something like that, they would mark a case ready not reached. I've never had a case marked ready not reached.
Mhm.
Just don't do it. And sometimes that meant staying to 8 or 9 o'clock at night, but
Okay.
rarely, just half
Right.
a dozen times or 10 times maybe in 30 years. But if you get a good reputation for being fair and being efficient and being in charge, you usually don't have any big problems with it. I mean, the rest of it sort of falls into place.
And
It's
dependable.
helpful somewhat if you happen to know anything about the law. It might be worthwhile.
Yeah, that might come into place, yeah. But it also means that court date is a dependable date. That's that on that date, everybody knows that something is going to happen.
Generally speaking, that's what happens. I mean,
Yeah.
sometimes things, somebody gets hit by a bus on the way in, or
Right.
an emergency operation or something.
Right.
But for the most part, if they have a date and we're ready to go,
Mhm.
and I have attorneys coming in and saying, "Oh, geez, I'm not ready," and this kind of stuff. And I remember a case, I won't tell you the attorney's name,
Good.
but in criminal court, actually I had 2 very similar to this at different times. And when we called the case for trial, the defense attorney said he wasn't ready. And I said, "Well," I said, "We're ready." He said, "We're ready to go." He says, "Judge," he said, "I can't try this case." He said, "Because I'm not ready." I said, "Well, the rest of us are ready."
Yeah.
Okay? And
And he had the
he
date.
said, "Well, I just can't do it." I said, "Oh, okay, you're not ready to go?" And he said, "Sheriff, take the man, hold him. I'm holding him in contempt," and immediately took him off to the cell room. Okay? And later on that afternoon, he was ready.
He was
to go.
ready?
Yeah, and, I had a similar reaction with another one, and see, in the Justice Center, it's easier because the cell room is only 5 steps
Oh,
away.
right,
So I just said,
right.
"Well, okay." I said, "I'm telling you, we have to be ready."
Yeah.
The funny part of it is, I don't remember about the second case, but the first part is, that was a Friday afternoon. And by the time I called several judges because he had a homicide case and all this, I said, "Well, he's ready, has to go."
Yeah.
And we did do the case first thing Monday morning, okay?
Yeah.
And I found this client not guilty. But,
There was some reward
Yeah,
somewhere.
but either way, the fact that I held him in contempt didn't have anything to do with the guilty or not guilty. But
No.
the fact of the matter is that after you do that once or twice, people know that
Yeah.
trial time is set, you have to go.
Sure. And that means that you're a dependable individual at the same time. Is there anything in particular about being a judge, or something you've done maybe, but it doesn't necessarily have to be limited to that? Is there anything that you're particularly proud of?
Yes, I was assigned to 425. I was doing major criminal trials at the time.
Yeah.
And my first wife, who is since deceased,
I'm sorry.
passed the bar. And I made an arrangement to have her swearing in my courtroom.
I see.
And I got Chief Justice Nix to preside,
Huh?
so that
Wow.
I had the honorable duty of moving her admission to the bar of Pennsylvania. in a full courtroom, in my courtroom,
Yeah.
Justice Nix presided. So I've always been proud of that.
That is special, yeah, very. Is there anything else that you'd like to share with us about your career as a judge? I feel that there's so much more.
Well, being a judge is a special opportunity,
Mhm.
and you have to understand the responsibilities and the duties you have. For instance, on my very first case, when I sentenced somebody to jail, and the sheriffs came in and took them off by the arms,
Yes.
took them and marched around the courtroom, I thought to myself, my God, did
Yeah.
I just do that?
Yeah.
It's sort of a little scary. Most people on the criminal side will tell you that I haven't had any problem with sentencing people, but it was unusual. But there's so many things. I mean, it's I think of it as this way, if you knew nothing at all about the law and came in, the law of averages should say you should be right about 50% of it.
Yeah, right.
And then if you have a little bit of knowledge to the law, you'll probably get up to about 70%.
Mm.
And then most of the cases that you see either are dead bang one side or the other, or leaning that way.
Okay.
And that pushes you way up. So you have a batting average of probably about 950% if you're doing pretty much what you should be doing.
Yeah.
But it's rewarding. I mean, I think generally speaking, I think we do extremely important work.
I agree.
I think unfortunately what happens is that people in different areas of the state think of the large urban areas as, well, they don't really do this. I mean, they do trials quickly and they
yeah.
do this kind of business,
Mm-hmm.
and I think we are extremely efficient here.
I agree.
And a lot of other places aren't. And I think I'm pretty efficient. We can move things along pretty well.
Yeah.
And again, people understand that. Like, for instance, when they come into my course, I'm doing jury appeals, and which most of the cases I can settle or mediate somewhere or another.
Yeah.
But when they go to trial, they know that this happens, and those people come in and tell me that this case is going to take a week or maybe 2 weeks. I said, no, I don't do 2-week trials. I said, I do 1-week trials. But it's rare that we go more than a couple of days. And I can remember one case I had in criminal court in that regard, in which they were charging the police officers down at the impoundment lot with stealing from the impoundment lot.
Right.
Okay. And in one case, in one of the photos, they told me they showed the police officer filling up his police car from gasoline that he drained from other cars.
Oh,
I thought that was a little bit off the wall, trying to get them for theft.
Right.
But the district attorney came to me beforehand with the other attorney and said, "This is going to take several weeks to try this case." And I said, "No." He said, "Well, no." He said, "Judge," he said, "I have over 200 hours of surveillance tapes." I said, "Well," I said, "you better get working on them," because we're not going to spend 200 hours.
Looking at
An hour will
tapes.
probably be right.
Yeah.
And then the whole case resolved upon a legal issue.
Oh.
When it got to the end,
Yeah.
the district attorney had never proved ownership or non-permission, which is what you need for
my
theft.
Lord, yeah.
They somehow or other thought those cars belonged to the district attorney's office, which just wasn't the case.
Oh, goodness.
So those kind of things. I mean, you could go on with stories and stories and stories and stories,
Yeah.
but I don't think I've done anything really out of the ordinary, and I think I've done pretty much what every other judge has done over
Mhm.
a period of time.
Mhm. Yeah.
Some like to take credit for this, and some like to take credit for that.
Yeah, that's true.
I think that when I did discovery court, I did that for 5 years or 5+ years.
Yeah.
And, you know, I think we disposed of 30 or 40, 50,000 motions every year.
I was going to say, there's a lot of activity in that court.
And we finally got to the point where I took my notes and I wrote a book on it, just for our own use, called the activities of the discovery court in case of procedures and things of that nature, which, you know, everybody used. So
Yeah.
not only did we dispose of those motions, but probably another 50 or 100,000 motions were never filed because they knew where it was going to go.
Yeah.
So, see, I think that's the other thing I think that people have to understand, that consistency
Yes.
is very important to a
Okay.
judge. To be,
Sure.
you know, not to decide something one day, different the other day. To, you know, if you stay on the line, it
Right.
should be okay.
Right. And that way there's very little confusion.
Well, the whole basis of our legal system is based on consistency or
Exactly.
precedent, however you want to do it. You know,
Yeah.
You expect when you go into a courtroom and you have A, B, and C that you should get a good result. Now,
Right.
of course, the lawyer on one side might think it's A, B, C, and the other guy might think it's D, E, and F, and that's where we have a problem.
Yeah. But nonetheless, that's
Yeah.
your job as a
Yeah.
judge, is
Yeah.
to interpret those sorts of things. Well, I've covered pretty much everything that I need
Okay.
to cover, and we've done remarkably well. I think in a short amount of time. I'm glad I finally got to meet you personally and got to know you.
Okay.
And I'm sure this information will be valuable to a lot of people.
Good. Okay.
Thank
Good to
you
see you.
very much.
Okay.